see the full screen. Not on our.
Oh, you can.
It's not on our
Okay.
screen. It's
Oh,
perfect.
that's good. Yep, I can see that. Okay. We just covered this section here about the people governing themselves seems like an anarchic idea. It's actually the most orderly method, and there's a means for doing that. We're just going to go on with this now. Um, and the basics of self-governance or governance by the people is the trial by jury. It says here, justice is created through the consciences of the jurors because the people, through the jury, are the final arbiter of law. And specifically in each individual situation, the individual defendant is afforded justice by examining intent and context. The jury are in authority over government legislation, and a lot of this is from this section here is from Will Keats' website, Law and Alchemy, and Common Law Constitution.org, both the .org. The jury are an authority over government legislation and can pass verdicts in opposition to legislation. This is known as annulment by jury. And this principle is still active today, but very, very few people know about it. And if you ever get called to go into jury service and you mention this while they're sort of in the selection process, you'll find yourself outside the courthouse very quickly. The people who run the legal system don't want people knowing about annulment by jury, despite the fact that there's a plaque on the wall of the Old Bailey enunciating exactly that principle. And it quotes the Bushell case involving William Penn and others who were accused of preaching religion against an act of legislation. The jury decided, well, this wasn't, there was nothing wrong with that. People should be able to talk about religion. So they acquitted Penn, and the jury was punished by the judge. The jury was imprisoned by the judge, without food and water for a couple of days. But there was when it came up for trial again, which was fairly soon, it was upheld, and that principle still is there today. The jury has the power to annul legislation by their consciences if they think that the legislation that's brought someone into court is unjust or unconstitutional. So naturally, the legal profession don't want people to know about this. They actually refer to it as a perverse verdict. We know the word perverse usually refers to things that people regard as sinful or somehow not right. So that's just another example of manipulation manipulating people's minds. Oh, that's a perverse verdict. There's something wrong with that. That's the implication by using that word. But it's still there, and occasionally you do get cases where the jury does annul a piece of legislation. There was a case in England just recently this year. Someone was charged under these new laws about freedom of speech, and he was charged under something, and it took the jury only 17 minutes to dismiss the case. They said, no, we've got freedom of speech here. The guy he hasn't hurt anybody with what he said. So they just dismissed the case. And so the principle is still there in some people's minds, and we are trying to expand the awareness of that in people. So the English Constitution is therefore compatible with natural law and what the universe permits us to do. The English Constitution properly places limitations on government such that it is so that people's individual rights under natural law are protected. And how is this done? This point here, this thing points about some of the things about trial by jury. A single juror in a case where legislation was annulled would be able to bring a publicly funded court action against legislators who had enacted legislation which caused harm or loss to people in violation of their natural rights. So parliamentary immunity would therefore be no more. Politicians would be just as answerable for their actions as everyone else in the community. This is how the trial by jury system originally worked and is supposed to work. The Crown's role in prosecutions would be minimal, mainly in cases where the victim was unable to plead, like in a murder case, or maybe if someone was murdered and they didn't have any relatives or anyone else that could bring a case against the person accused of the crime. So the Crown would obviously be active in that situation. Professional advocates like lawyers would become redundant, as would magistrates and judges employed by one of the interested parties. I mean, a magistrate or a judge is employed by the state. As all cases involve the state against somebody, there's obviously a flagrant breach of the concept of impartiality. Cases would be heard by the jurors, assisted on points of law by elected conveners well versed in law. The plaintiff and the defendants would be the only ones to address the jurors, apart from witnesses and or required experts. For example, you do have cases where there's a lot of technical knowledge required. And obviously you'd have to have people who knew what they were talking about to advise the jurors in these cases. Most cases now occurring would not materialise, since there's no underlying crime involved in most of them. If we had this system working today, for example, there'd be very few cases brought where people were brought into court for non-payment of a parking fine, for example, or even a speeding fine where no harm or damage was caused, and obviously it wasn't too extreme. A lot of the things that we get prosecuted for, there's no victim at all. It's just a revenue-raising exercise for the state. And when I say the state, I differentiate that from the Crown. The Crown is actually the ultimate repository of lawful authority under the English Constitution. The Crown isn't the monarch; it's an abstract principle, to which everybody in the community subscribes. For example, everyone in the community realizes, well, we shouldn't be killing people, we shouldn't be stealing from each other, we shouldn't be committing fraud or defaming each other in order to cause damage. These are things that are universally agreed, and the Crown is there to. That's the actual symbol that represents these things. The monarch is just the office bearer who is supposed to fulfill the role of the Crown in upholding the rights of every Crown subject. And the monarch, of course, is a Crown subject themselves. So we look now into how these things have become corrupted. Man-made legislation, acts, statutes, and policies are not the law. Natural law is. And here we've got the law of freedom, morality here under this heading. When human beings in the aggregate live in harmony with natural law and are therefore moral, they become and remain free. As aggregate morality increases, aggregate freedom increases. And this dynamic of natural law we refer to as the law of freedom. This is from Mark Passio, a lot of his thoughts here. When human beings in the aggregate live in opposition to natural law and are therefore immoral, they become and remain enslaved. As aggregate morality declines, aggregate freedom declines. The law of freedom is just as immutable as the physical laws that dictate a car engine won't work, unless every law pertaining to its constituent parts is complied with. So it gets back to that initial point we had at the beginning. If we want something to be manifested in reality, we have to create the conditions where that's possible. And as long as more people are content to live under a form of slavery where some people are able to coerce and extort others. That is an immoral attitude, and the more people who subscribe to that, the worse things are going to become. Um, it's just as simple as that. We need more people saying, "Well, no, this is immoral. What's going on?" And I'm going to speak out against it. Um, in the situation that we're in at the moment, uh, where there's a growing number of people who realise there's something seriously wrong in the polity of the nation, that there's a whole heap of things that are not right. And we've got things like the so-called freedom movement that are designed. They're striving to change this and bring about some sort of reform. But if they don't access what is the real law, what's the true law, and then try to act according to that, they're not going to achieve any not going to achieve any progress. We've just got a whole groups, lots of different groups of people all arguing about what the solution ought to be, but it is quite clearly written in the law, and we've been people have been confused by a lot of the time by deliberate action by the government and by the legal profession, into not knowing which of these many sort of proposed solutions is the real one. And it reminds me of we've all seen the fairground trick where the guy has got the three cups and the ball underneath. We've all seen that one where they switch them all around, and it's very difficult to pick which one's actually got the ball under it once all the movements are finished. But if you imagine that's how the government and the legal profession have boggled the minds of the population. They've got all these different ideas going around that are conflicting. Imagine somebody trying to do that trick with only one cup. Do you think that would work? If they only had one cup, no, you'd be able to tell exactly where the ball was at all times. So it's important that we try to discover what's the true answer to these things. We talked a little bit about rights before. Where do rights come from? They come from things that we do that are in accordance with nature and that support the natural law. Law is a derivative of rights. When there's general agreement about rights, law will follow. Rights become recognized when people follow their consciences, realizing that others desire or need the same considerations that they afford themselves. This is the origin of natural or common law, which is enshrined in any lawful constitution. So we've got under rights, there are certain things that people regard as rights, and we could class these as natural or negative and legal or positive. Why do we use these terms negative? Well, natural rights, we have the freedom to seek survival needs. We have a freedom to be free from assault or coercion. That is a right. From fraud or deception, from theft. We possess in nature the freedom of speech, of movement, of association, who we associate with, and to own property, including our own selves. Refer to these as negative rights because they don't require any input from anybody else. They make no imposition upon anybody else. On the other hand, legal or positive rights, these are things that we could list as, say, people think, I have a right to an education or to free healthcare, to government welfare, the home or shelter, food and clothing, a minimum wage, silence or the right to silence or censor opponents, right to public transport and subsidized childcare, etc. The list is really endless. And the problem with those is that they have to be granted by an authority, otherwise they don't exist. They impose costs or demands on others, so they cannot apply equally to all. They can be removed at the whim of legislators, and therefore they're only ever temporary, a major pitfall of democracy. in inverted commas. They can be manipulated by power brokers to secure wealth and influence for a select few. On the other hand, the natural rights exist in and of themselves. There's no grant necessary. There's no demand or costs on others. They can only be removed by force, deception, or consent. And being part of nature are immutable or eternal, as with natural laws of physics. So these laws, the rights that we have, that we're born with, are just as eternal as the laws of physics. We can't change them, no matter how much people might try. So now, this is a brief history of English law. In the Dark Ages, England was ruled by what we might term warlords. They called themselves kings. Um, the country consisted of several separate such states known by such names as Northumbria, Mercia, Anglia, Wessex, and so on. And these were subject to periodic invasions by marauding foreign tribes such as the Danes, the Saxons, even the Scots. England finally united after many difficulties into one country under Alfred the Great, who was classically educated and understood the value of concepts like trust, honour, and rights. Under Alfred, much of English common law was codified. In other words, it became the official means of applying justice throughout the kingdom. Because of these achievements, he remains the only English monarch to bear the honorific the Great. Alfred was the founding father of the English state. He was very well educated by his father and grandfather in these things, and he was very strict about it. He was reported to have hanged a number of judges who overrode the verdicts of juries and had people hanged when the jury had said they were to be acquitted. Alfred took a very dim view of that, and he had some of these judges hanged. He said, "No, the jury is they're the people who decide what the law is." So succeeding monarchs were of various and often dubious quality, culminating in the infamous King John. I think John came to the throne in 1199. We'll get back to him in a minute. So there's a difference between lawful and legal, and this is something that the powers that be, I call them the powers that be rather than the authorities. They don't have any authority, they have powers. Lawful things stem from natural law, which binds all people equally. It's immutable, it's not susceptible to change or amendment. It forms the basis of common law and overrides statute law. Lawful defines constitutional law and protects individual rights. Legal, on the other hand, consists of statutory legislation passed by a parliament or Congress of Representatives. It can be changed by any succeeding administration, and it favours one-size-fits-all judicial processes and punishments. But the important thing is it's null and void if breaching constitutional or natural law. And of course, the people who are running the country at the moment and running the judicial system, they actually deny this. So you can point these things out to them in a court and they'll just flat out deny it, which means that they're committing sedition. They're denying the validity of the Constitution as it exists. And that was defined to a large extent by the Great Charter, Magna Carta 1215. The Great Charter, or the Great Charter of Liberties. It's the primary document of the English Constitution, but it is not the Constitution that already existed under common law. Magna Carta just simply affirmed some of that and was formally agreed to by King John. And this is a picture of him there sealing. He's actually signing there, but he sealed Magna Carta with the seal of the monarch, and that applies to in perpetuity. It binds all future monarchs because it's not an act or statute. It's a treaty between the monarch, in this case John, but it applies to all succeeding monarchs, and it's therefore different from an act or statute of Parliament. Magna Carta predates Parliament by decades. The House of Lords came into existence in 1235, about 20 years after Magna Carta. The House of Commons in 1263, so that was even generations after Magna Carta 1215. This one we'll come back to in a little while. This is actually the answer to the problems that we have at the moment. And when John was tried by the barons, he had been a very violent monarch. He had people murdered. He'd just taken their lands from them without any compensation. He'd also taxed people extremely heavily for his wars that he wanted to wage. And eventually the barons said, no, look, you just can't go on like this. Either you honour your coronation oath and start protecting people's rights that you swore to uphold, or, or else, which I presume we could presume meant they'd choose another monarch. He would either maybe be probably the usual penalty in those days if somebody fell out of favour with the authority was to be exiled. So he would probably have been exiled. But he decided to agree to it. But of course, he really didn't like that and immediately set about trying to find a way to get around it or to nullify the charter. There are 63 articles in the charter. This is 61. And this is the one which is a security clause. And I won't read it all the way through, but some of you have probably been reading while I've been talking. But he says here, because he wanted to allay the quarrelling that had arisen between us, so he's using the royal we there, us and our barons, we have granted all these concessions, desirous that they should enjoy them in complete and firm endurance forever, and we give and grant to them the underwritten security, namely, that the barons choose 25 barons of the kingdom, whosoever they will, who shall be bound with all their might to observe and hold and cause to be observed the peace and liberties we have granted and confirmed to them by this our present charter. So that if we, or our justicia, or bailiffs, or any other officers shall in anything be at fault towards anyone, or shall have broken any one of the articles of this peace or this security, and the offence be notified to 4 barons of the said 25, the 4 barons shall repair to us or our justicia, whether in or out of the realm, and laying the transgression before us, a position that to have that transgression redressed without delay. And they're given a certain time to do that, 40 days. And if it's not done, then here we've got in the yellow here, those 25 barons shall, together with the community of the whole realm, distrain and distress us in all possible ways, namely by seizing our castles, lands, possessions, and in any other way they can until redress has been obtained as they deem fit, saving harmless our own person and the persons of our queen and children. And when redress has been obtained, they shall resume their old relations towards us. Okay. This is an important bit here as well. Let whoever in the country desires it swear to obey the orders of the said 25 barons for the execution of all the aforesaid matters, and along with them to molest us to the utmost of his power. And we publicly and freely grant leave to everyone who wishes to swear, and we shall never forbid anyone to swear. This is vitally important here. All those, moreover, in the land who of themselves and of their own accord are unwilling to swear to the 25 to help them in constraining and molesting us, we shall by our command compel the same to swear to the effect aforesaid. So I won't go through this any further at that point, but that there in the red is that is a law that is in effect right now. And everybody in the British Commonwealth is under a royal command to unite with these barons and dissent from the government that's been declared unlawful. And that is the actual law. It was invoked on the 23rd of March 2001 by the 25 barons, and it's therefore one of those things we referred to in the beginning. If you want something to come in to be manifested in reality, you've got to do what's required. And this is what's required for the unlawful government that we have at the moment that's committing all sorts of offences against people to be brought to heel. It'll probably take about 10% of the population to swear this oath to the barons to refuse to comply, to distress and distrain those claiming to be the crown, and the system would be unworkable. That's the simple answer, and it's not. That's why I refer to the three cup trick with the ball. It's not a complicated thing. The law is simple, and the reason it's simple is because everybody can understand natural law. A child of 2 or 3 years old knows when they're being infringed against, if they're having their property taken away from them or they're being assaulted by another child. They know instinctively that's not right. And usually the adults there will teach them as well. Yeah, that's right. You can't do that to the other child, and you've got to be, kind and decent to each other. So we'll come back to the last part of this Article 61 at the end of the presentation. So we come to this question here: who can write a constitution? Well, it's virtually anyone other than government, or everyone other than government. But the bottom line, not the government. The government cannot write the constitution and also have exercise the authority or the power to enforce the rules that they might come up with. The rules have to be written by other people to control the government. Otherwise, the government will just run amok. So the Constitution must bind the government, not the people, because the government has a monopoly on the initiation of the use of force. So neither the government nor any arm of it may amend the Constitution without the express consent of the people, who must remain free to act in any way they wish, providing they abide by the 4 tenets of common law, which is, as somebody mentioned earlier on, do no harm, cause no loss, commit no fraud, and keep the peace. It's simple. The law is very simple. We've had thousands of pieces of legislation piled on top of the law since the time of Magna Carta, and that's all done to befuddle people, to condition them to say, oh, well, this is the way things are done, and we don't have any real choice about it. But we do have a choice. It was mentioned democracy before. What it is not suffrage. Voting in elections leads to totalitarian, communist, fascist states. Suffrage creates consensus of voting. Majority rule is still a form of dictatorship. Referenda is the same problem. Legislatorial voting by representatives negates individual responsibility for upholding the rule of law. This is part of the problem, where people have been content to just, let's leave this to experts, people who've got more money and more time, and they can sort of look after these things, and we trust them to look after us. But well, it turns out that when people are given power to do things that other people aren't allowed to do, they're not very trustworthy, it turns out. Ricky Gervais pointed that out recently when he said, of course, the people in charge aren't trustworthy. That's why they're in charge. They've assumed that asserted those roles to themselves because they're not trustworthy, and people have let them get away with it. This is the meaning of the word democracy. It comes from the Greek demokratia, demos, the people, kratos, sovereignty, and kratine to rule, derived from the Hellenic Athenian constitution. So government by trial by jury and sovereignty of the individual citizen juror as the final arbiter of law. I don't like the word citizen there. I'd rather use subject, subject of the crown, not subject to another person, subject to the symbol, the ultimate symbol of justice, which is the law that everyone agrees to. You know, if you look at all the laws that were in, all the legislation that's written, you find people disagreeing with, you could pull them out at random and people would be disagreeing with certain aspects of almost all of them. But when it comes to the actual basic laws, you know, that we talked about just now, virtually everybody would agree to that. Yeah, we shouldn't be doing each other any harm. We shouldn't be defrauding each other. You know, we should be upholding the peace and so on. They're simple things that everybody can agree to. So under trial by jury system, the jury decides what's admissible as evidence. There's none of this, oh, this guy's got, 10 previous convictions, but we don't want people to know about that. The jurors decide that. The jurors are the judges who may be assisted on points of law by an elected convener. The jurors judge the facts of the case and the justice or otherwise of the legislation. Okay, so if they think it's repugnant to the Constitution, then the legislation, they can annul that. The jury decides the verdict and sentence, if any, and the jury may annul the legislation and acquit someone technically guilty of a breach of the legislation which flagged the case. A single juror may bring a publicly funded court action against legislators, singularly or in plural, for any damage caused by unconstitutional legislation they enact. That would be, we can see here that this simple version of the trial by jury system would negate almost all of the things that people are struggling to introduce as a means of reforming the government. You don't need new constitutions, loads of other new laws. You simply restore the trial by jury system, where the jury says, well, this is a waste of time here. In fact, we might award costs against the constable for bringing this case and wasting our time, where there was no victim. And it wouldn't take very many such instances before a lot of those laws, legislation would just wither on the vine. They'd just never be used again. You wouldn't even need to repeal them, although you could do. So the trial by jury system is the means where the people control the government, and you don't have to sign petitions begging these people who have assumed the right to rule over us for rights that we already possess. So we're looking now at the treason of the Bill of Rights, how this has been, how Magna Carta has been suborned or corrupted. The Bill of Rights in 1688-89 it's hailed as the start of the Glorious Revolution. That's what the powers that be would like us to consider it, but it's not. It was a treason. Claims made on behalf of the Bill of Rights, which occurred when William of Orange was installed on the English throne in 1688, which was basically a coup. Well, the claim is that it asserts the right of Parliament. It asserts the rights of the individual. Those are two contradictory claims if you think about it. And it assures a Protestant political supremacy. In other words, you can't be the monarch if you're a Catholic, because Catholics ostensibly have got, of course, a different type of duty to a foreign potentate, the Pope. So they say, well, you can't have, whoever's in charge, whoever's on the throne has got to be only involved, only in support of the English Constitution. They can't have mixed up with, someone in a foreign country who may want something else to be done.
Yeah.
But the actual outcomes of the Bill of Rights, it legally, as you see inverted commas here, abolish the monarch's constitutional right and duty to withhold royal assent when necessary to negate unconstitutional or treasonous legislation. It actually says in the Bill of Rights that it was illegal for the monarch to exercise their royal prerogative and deny royal assent to anything that Parliament said. So the next thing it says, asserted Parliament's constitutional supremacy over the monarch and the people. Um, that's completely against natural law, isn't it? Uh, if everyone is born equal, how can one group of people suddenly become supreme over everybody else, including the monarch, who's supposed to be the umpire of what's constitutional? So that is a blatant. See, that's while it says here it asserted Parliament's constitutional supremacy, there's nowhere they actually say that in writing. It's just implied, right? You couldn't really say that, otherwise it would be open treason. What it did do, though, was bury the right to trial by jury and annulment by jury. This trial by jury system started to be undermined as early as 1270. By 1270, already 50 odd years after Magna Carta, moves had been made to restrict people from jurors who weren't landowners. So it was already sort of, which obviously was most people. Most people weren't landowners in those days. And obviously women, for example, weren't allowed, they weren't allowed to own property. And even under Magna Carta, that was one thing that was changed by a piece of legislation that improved Magna Carta. Under Article 7, when a widow had to leave her husband's house after he died, she had a certain amount of time to leave the place. And obviously that was unjust, and that's been remedied by legislation that improved